in the matter of Colin Township versus Alfred E. Yoder and Joanne Yoder. You're Alfred Yoder?
Yes, sir.
And you're Joanne Yoder?
Yes, sir.
And the township is represented by Mr. Lance Thornton, who is also present. Mr. Yoder and Mrs. Yoder have represented themselves throughout these proceedings. They have a right to represent themselves. I recommended they get counsel. They do have some legal advisors, but they are here on their own behalf. I had hoped to get to the end of the finish line here in this case, but we aren't there yet. We took a lot of testimony through the spring and summer. On October 15th, we had a final hearing, and the court issued an order for indemnification / restitution. And another order following civil contempt. Then there was another order issued on November 5th, and another order on November 5th regarding each case. Denying the motion to set aside the default and the original order for the cost portion of this. Mr. and Mrs. Yoder have filed a number of motions in each case. Kind of trouble sorting them all out. But I have before me a proposed order on motion for sanctions, order granting defendants motion for sanctions and finding fraud upon the court. Proposed order granting defendants motion for reconsideration, vacating void portions of prior orders. And then supporting that is entry to objection to entry of order and notice of inaccuracy under MCR 2.602B3. And then they filed a brief in support of application of law, recognition of compliance and void judgment doctrine. And brief. And then they filed something called a declaration of AI forensic analysis and findings. I think AI assisted in preparation of these. Defendant's motion for reconsideration, correction of factual constitutional errors, and motion for sanctions and fraud upon the court. So I think there's actually 3 actual motions. Motion regarding cost, a motion for reconsideration and correction of factual orders, and motions for sanctions and finding of fraud upon the court. Mr. Thornton got the same set of pleadings I did. The ones I quoted from were from the 25040 case, and I believe there's a parallel set in the 25533 CZ set. So they filed a motion for reconsideration on the other matters, and the court can't simply ignore it. So we set them for hearing. Who's going to speak for you? You, Mr. Yoder? All right. I think we've resolved our question about all rise. I guess the simplest solution is just people that don't object just come in after we start and sit down, and then we avoid the whole rigmarole. All right, Mr. Yoder, what do you want me to know?
What don't you understand?
Well, I don't understand most of it, to tell you the truth. What are you asking me to do?
Well, I thought if I can understand it as a dumb Amishman, I got to the point where it actually makes sense.
I wouldn't use the term dumb Amishmans. They're some of the cleverest people I've encountered, but, so call me a dumb judge. So
No.
you filed these 3 motions and I don't exactly know what it is you want me to do.
All right, let's run with the objection to entry of order and notice of inaccuracy under MCR 2.602.
All right.
According to the transcript from the last hearing, we were ordered to pay fines at a cost.
Yes.
All right. And this letter that I got, the defendants shall pay restitution to Colin Township. Restitution amount leaving a balance of $2,449. Then the court said within 30 days, some reason or other, this paper that is left blank. This isn't the paper that I wanted because it's on that paper that we're held for civil contempt. We owe the township for incurred pecuniary losses and that restitution is owed. That's not even what the court said.
Well, I went back and watched the video. I've left these up. Usually I take things down on or after 30 days so I could review things. And I looked at what I said on the 15th. And it may be just a matter of semantics, but this payment is going to Colin Township.
I realize that.
Okay.
I have the transcript from that court date. Not with me, but we have the transcript.
Oh, very good.
And that's not the wording from the court.
Well, it's the wording that's in the order. The court stands by its order. So, Mr. Thornton, do you wish to respond to that?
Sure. Defendants object, and part of the problem is their objections address 2 different orders, one in each different case, but they've got just one objection. So they object that to the finding that defendants committed civil contempt. The defendants did commit civil contempt, and the court made such a finding. Defendants further object to the language regarding the township incurring pecuniary losses and the restitution, that restitution is owed. Again, the court did make these findings. The court may have said costs, but it's not just taxable costs, it's restitution. And in my motion for the restitution cited the MCL statute, and that's in the order. And the court agreed and ordered it under that statute. And that is for costs and restitution to the township. So we're not arguing over the amount. That was clear what the court ordered. Although I did the follow-up order because Your Honor had marked up an order that I had pre-prepared that
Looked pretty bad.
Yeah, so I clarified it with more time after the hearing. So again, the court did make those findings. So whether you call them costs or restitution, it was clear under what statute the court was ordering it, and it was clear that the court did order it. The defendants complained that the orders were not circulated before they were filed. I'm assuming they're saying before they were filed with the court. Well, the court rule doesn't require that they be circulated before they're filed. They were filed with the court under the 7-day rule and mailed the same day to the Yoders. That's the whole idea behind the 7-day rule. There is no requirement that the proposed orders be provided to the Yoders before they are given to the court. The court waits 7 days for the Yoders to present their objections. And then if no objections are received within that 7-day period, the court signs the orders. And in this case, the Yoder's objections come in after the 7-day period expired, but and the court did go ahead and enter the orders. So I'm not even exactly sure.
Well, the order complies with what I ordered.
Exactly.
And the court speaks by its written orders. And I went back and looked at what I said, and I tried to explain. I lowered some things that you'd requested. We came up with the amount of $4,449.94. I allowed that the bonds that the defendants had been posted could be applied against that amount, and the amount remains the same, $2,449.94. So the defendant's objection to entry of that order is denied. Mr. Thornton, you can prepare an order to that effect.
Can we fill in the blank on the order as part of this order denying and how many days they had to pay the $2,449.94?
In let's see, 40. Yes, it should have said 30 days, but now an additional, so today is the 3rd. I'll make it 30 days from today. So the original order was within 30 days of October 15th. The amended order came in on November 5th. Was sent out. And so now I've reconfirmed it. So November 5th to December 3rd is 28 days. Paid within 58 days, amended. Defendants have 58 days from November 5th. Pay the balance. The $2,000 may be transferred.
That's been received, Your Honor. The court has transferred that to the township, and I delivered them their check. So.
All right, you have essentially 30 days from today to pay that $2,449.94. So, Mr. Thornton, would you do an objection denying or do an order denying that motion and granting the defendants 30 days from today to pay that amount? Yes,
it's not necessarily the pricing, that's right.
Yeah.
That was correct, but it's the way it was worded here, and then what the things that he reworded differently, that hits us, because it's like it's not exact, it's not how it was given in court.
Well, as I said, I listened to it, and the statute entails costs and restitution, and costs go to the court generally. In certain types of violations, they go to the city or village. Fines go to the libraries. That's a whole different can of worms in criminal cases, but this is a zoning violation matter with a civil contempt. So what I wanted to make sure was that the township got the money rather than the court. And that order makes that happen. And so I'm satisfied. And I did try to explain it, and maybe I didn't explain it very well. But that original order stands. You have 30 days from today to pay the amount stated, which is 2,000. $449.94. That's the first motion. Let's take the next one.
What date does that come up to?
Well, 30 days from today would be January the 2nd. First business day of next year. All right, that's this one. Next we have, trying to keep my motions. Motion for reconsideration and correction of factual and constitutional errors.
Your Honor, are you understanding it, what we gave you, or do you want us to read everything?
Well, no, I certainly don't want you to read it. I read it, but could you help point out exactly what it is you want me to do? I read it more than once. Some of this is AI generated and it's hard to track. It doesn't look like a normal legal pleading that the court sees. So let me ask, which I would ask any party, you filed a motion. What is it you're asking me to do?
Right, how can we have a case, a legal case, if there's a whole bunch of illegal stuff going on in it?
That's the essence of your view.
Exactly.
Okay. Now, as I've recited a couple of times, I came into this matter in midstream.
Yeah, I realize that.
It had been going on for some time, and you were given a notice of default. You did not appear. Default judgments entered. You did not move to set the defaults aside. I did not grant a motion to set the defaults aside, and I allowed both default judgments to stand. That happened all before I got here, and then I've been dealing with everything since then. And there's a difference between being ignorant and being dumb or stupid. You're not dumb or stupid, but people that aren't lawyers don't always understand the law. Sometimes the lawyers don't understand it, maybe judges too. So this stuff is complicated. And so you try to step back and look at it as a large framed picture saying something looks out of whack here. And then when you get into it and you take all the testimony and we take all the time that we did, I made the finding that I did. And I stand by it. And this is a recent phenomenon, particularly with AI assisted. You go through a long, arduous hearing, spend time at night, evening, going over everything, take all the testimony, make a ruling. Then they file a motion for reconsideration saying, well, I don't want to do this all over again. I already made my ruling. I don't want to go through the whole process in a reconsideration. Mr. Thornton, what have you made of this motion for, and I think they're parallel motions in both 4-0 and 533 case. The defendant's motion for reconsideration and correction of factual and constitutional errors.
Well, first off, the township opposes all the recently filed motions. And I'm a little confused because when I first got the 40-some pages of filings on October 31st of 2025, I contacted your Honor's office because I was wondering what we were going to do today on 12/3 of 2025, since there were additional motions filed in addition to the objections to the two orders. So, and I communicated by email with your Honor's secretary, and I was informed, and I have copies here if your Honor wants to see them, that the last response on November 5th was the hearing is just on the objections they recently filed to the orders.
What was intended, we were just gonna hear all the motions, so I'm not sure if something got lost in the translation.
So
you're claiming you don't have notice for hearing on these motions?
I don't, based on that, I didn't file a response to the motions. I'm wondering how many post-judgment motions the court's going to allow the defendants to file. I don't know what we're up to. I would have to set through and go through the files, but there's been several in both cases, and all have been denied. And so, yeah, our position is no, I'm not, I didn't file a response. I'm not.
Well, every time they file something like this, with the aid of their assistants or AI, it costs the township thousands of dollars to respond to them.
Correct, and especially when we get them in the form of 40-some pages, addressing with the two cases mixed together and the documents mixed together, and I have to take the time to sort through them, which I did take the time to read through all of them. Nothing has changed. The same arguments are being made that the court's denied in the past. So based on that, and based on the email I had received from your Honor's office, I didn't file written responses. The township does object to the orders and opposes or objects to the motions and opposes the motions. The judgments have been granted. The defendants have not shown anything that would require the court to overturn its rulings. And as the court has stated in the past, if they didn't agree with your Honors in this court's rulings, they have the right to appeal.
Yes. I'm
not even sure where the appeal would stand at this point because of all the subsequent motions that have been filed post-judgment. So I guess if the appeal occurs, we'll have to sort that out.
Well, all right. Regarding this first motion for reconsideration and correction of factual and constitutional errors, it's got some exhibits attached to it. I don't comprehend it very well. Township objects to it, and I'm gonna deny it, and defendant can appeal that to the Court of Appeals with everything else.
Your Honor, and could I add for the record that all of these motions that get filed, the one thing the defendants do not do is set them for hearing.
Yes,
and get a hearing date and send out a notice of hearing, which is required of them to do. I realize they're not acting as their own attorneys. We all know somebody else is acting as their attorney, but that is their obligation under the court rules, is to set it for a hearing, prepare a notice of hearing and serve it on me so I know what we're here for on any given day.
fair response. In the courts, I don't know what, just a minute, I don't know what they would do in circuit court. In Judge Noacker's day, people would file something in the circuit court file and nobody would even look at it. It'd get put in there and it'd be a year and a half later and the parties call up and say, hey, what happened to my motion? I'm a district court judge sitting in this zoning matter, which I do lots of these, but it's in a circuit court context with the circuit court county clerk being responsible. So I have to make sure that I'm complying with how they do things. But I said it, I didn't want to just leave it in limbo. So in each case, I've set these for hearing. And the motion for reconsideration and correction of factual errors is denied. You can appeal that also to the Court of Appeals. I don't understand it. Township objects to it. And if you can get the Court of Appeals to confirm it, then maybe they'll understand it better. They will not be lax upon the filing of the rules. They've got very strict rules on filing and briefing and deadlines. So that appears to be the third motion. That's in both the 4-0 case and the 533CZ case. Now this one, I didn't understand. Motion for sanctions and finding of fraud upon the court. Again, I'm not exactly clear what that is. The two cases kind of intersperse. But this also has to do with the money, the $2,499.94. And you object to that order and you want finding of fraud. Again, I'm not sure I completely understand that. Mr. and Mrs. Yoder, what are you asking for in that case?
Well, I guess the way I understand the laws, if you read all this stuff, if the judge says one thing and the attorney writes letters stating other things, that's technically fraud. In my book, I'd say he's lying. Plain English. Like I said, we have the transcripts, and no, that does not match up with the transcripts.
All right.
So in plain English language, that's fraud.
Now this order, this motion is a little better because it has relief requested. You're asking me to find the plaintiff's counsel proposed order failed to conform with the court's oral ruling that was submitted in bad faith. 2, to declare the October 22nd, 25 written order void to the extent it includes findings or language not stated on the record. 3, strike any reference to civil contempt, restitution, or pecuniary losses from the case record. 4, impose sanctions, including defendant's reasonable cost for preparing this motion and correcting the record. 5, direct plaintiff's counsel to show cause why further disciplinary action should not be directed to the Michigan Attorney Grievance Commission for violation of conditions of the canons of ethics. 6, grant such order on relief as just and necessary to preserve the integrity of this court. That I can understand. I don't know if that was AI generated or otherwise, But I don't find that he committed a fraud. I don't find that the order was issued in bad faith. And in my earlier order, I've declined to strike those matters. And really, it's a matter of semantics rather than the amount, as I indicated. And I looked at the record from that day and tried to explain that amount I calculated after hearing evidence. I deducted the amount of the bonds from that, and I wanted to make sure that the money went to the township rather than to the court or the state of Michigan. So your motions for sanctions and finding a fraud upon the court is also denied. I don't find there was a fraud on the court. I don't think Attorney Thornton acted in bad faith. He was trying to interpret my ruling as well, and the order accomplished that.
Your Honor,
Yes, sir.
can I call somebody to witness?
No. You can't. This isn't a testimonial hearing. I tried to get this case to the finish line, and to your credit, you have ceased birthing operations at Mama's house. We're working on getting the other building in a position where you can utilize it. You may wish to open your enterprise in another jurisdiction that would welcome it. I don't have any objection to that. But I wanted to bring this case to a close. I found my default orders remained in effect. I tried to calculate what I thought was a fair amount, which is much less than their actual costs. And I want to keep treading the same water. So I meant what I said on October 15th and in my previous rulings in this case. So each of your motions, motion for sanctions is denied, motion for rehearing is denied, correction of constitutional errors, and the objection to the order is also denied. Mr. Thorne, if you would prepare those, then you can appeal this to the Court of Appeals. My feelings won't be hurt if the Court of Appeals disagrees with my ruling in this matter. I didn't seek this matter out, it landed on me. And I want to bring it to a close. So each of your motions was filed. You didn't notice them, the court noticed them. So Township was a little bit confused as to what exactly we were doing. I may have added, I'm not out to look at that email response. Anyway, all three of your motions, the best one was the last one, but at least the best understandable one from my perspective. So we'll send you a copy of those orders. You have until January 2nd to pay the balance of that. We'll call it restitution. And if you wish to appeal it, I wish you all the best.
Your Honor, I would like to comment.
Yes?
The allegations of me committing fraud against the court and making misrepresentations to the court are offensive. As I stated before, we all know the Yoders are not drafting what they are signing and submitting to the court. The documents the Yoders are signing are being drafted by someone who is providing legal advice to the Yoders and who is covertly acting as their attorney. However, that person is ignorant of or doesn't understand the court rules or court procedure. And by signing those documents, everything stated in those documents becomes the Yoder statements and legal arguments. I practiced law for 36 years, and I have never knowingly misrepresented anything to this court or any other court, and the Yoder's allegations, again, are extremely offensive. Your Honor made the findings and rulings that are set forth in the orders, and Your Honor signed the orders I submitted. I assume Your Honor would not have signed the orders if the orders failed to represent your findings and rulings. So I do appreciate the court's comments today.
All right, and they did, and you and your efforts have the respect of this court. You do a very fine job representing your clients. Yes, Ms. Yoder?
So we are getting help from different directions, yes. AI has been our crutch. Best thing that we could, best resolves that we could get. And AI is to the true fact. It is not illegal. That is legal. And AI does know.
Well, I didn't say that it was illegal. The legal world hasn't quite caught up to AI. Some of it can be very helpful. In fact, it's gonna dramatically alter the practice of law. Right now, it hallucinates. It finds facts that aren't real. It makes things up. And parties have been filing stuff without properly vetting them. Some attorneys and even some judges have gotten profoundly embarrassed by not vetting or verifying the information filed in the briefs. I didn't make a finding that your information is false or a hallucination. I simply disagree with it. As this gets better, it is going to change the way we do everything in the world. I was at the judges conference in May in Detroit, and a speaker spoke to about 600 judges with an AI presentation on legal briefs, and we were stunned. So yes, it's certainly not illegal. It has its uses, it has its drawbacks, but I've made my ruling. I want you to pay that money by January 2nd to the county clerk. The matter will be concluded. If you wish to appeal it to the Court of Appeals, feel free. Yes,
Your Honor.
Yes, sir.
What did he say that happened to him when we filed that he had brought up on the court?
I don't remember, but you were here. I don't want to get into a personal.
I don't remember what the name he had for that. It wasn't humiliated or whatever he called it.
He was offended.
Offended.
Yes, that sounds like a good word. If I was him, I'd have been offended too.
How does he think that we're feeling with what we've got going on out there?
All right.
And we tried to be a plain person, live a plain life. We even asked him and his safe built guys for advice, and this is where we're sitting. Now, you think we're not humiliated?
I certainly would say frustrated. All right, we'll be in recess. I don't need any further enlightenment. Thank you, Mr. Thornton.